Good afternoon, everyone. Today we have our privilege of hosting a patent powerhouse, none other than Eddie Walker. So from the FBI Rise Sydney. So he's the partner of the FBI Rise Sydney and also the registered Australian patent attorney. Eddie's expertise spans across a very broad range of the technological marvels, like from the medical advancements to the semiconductors and optical engineering. So from her major in the physics, I think, yeah. So he masters the art of the drafting and prosecuting the patent applications worldwide. And so today we are very happy to have him here to reconnect with us in person. So we've already have a long-lasting collaboration with FBI Rise to help with our spree researchers in the patent application. So no more ado, I will hand over the time to Eddie to please enjoy these enlightenment sessions, not just for the informative sessions, but also maybe some potential patent worthy in itself. Okay, thanks.
Thanks, Baron. Much appreciated. So, thanks for everyone attending here in person today and watching perhaps in the future the recording. I'm going to be giving an IP overview. So some people may find some of it basic, but still find some new snippets of information. For some people, it may be completely new. So hopefully there'll be something for everyone. I'm a patent attorney at FB Rise. I work for many, research institutes, universities, companies, individuals, and I've got a background in physics. We have to, as patent attorneys, have a science degree. That's critical. Some patent attorneys have law degrees too, but not all. The science is key, and the rest comes through professional qualifications and doing the job. An acknowledgement of country. We acknowledge the traditional custodians of country throughout Australia and their connections to land, sea, and community. We pay our respects to the elders past and present, and extend that respect to all Aboriginal and Torres Strait Islander peoples today. Brief disclaimer. This is the FB Rice team for UNSW, so there's a lot of us. We're a sort of reasonable sized firm, and a lot of our attorneys have connections and work with UNSW. So whether that's on the photovoltaic side like me or the chemistry side, there's a number of us who have the joy of working with the university. And where do we sit? Well, this is sort of a diagram here. We have yourselves, university inventors, we'll call you, and the research teams who come up with inventions. They talk to the UNSW Knowledge Exchange, a number of members here today. Work through, we'll talk a little bit more about the process, but work through whether there's an invention, something to protect, and then that's when we start to get involved at FB Rice, and we're in between the university and the Patent Office, the Australian Patent Office, which is there's the Australian Government IP Australia emblem at the top left there, and but we also work with foreign attorneys like ourselves and effectively foreign patent offices to secure protection for IP rights around the world. So I'm going to go through some of the types of IP that exist, intellectual property. Some people try and define what intellectual property is. They give it a go. Creations of the mind, products of human intelligence and creation. Intangible property that is the result of creativity. But it's only sort of so useful to hear these phrases, and it's typically better to look at the types of IP that actually exist. So I've got an image there of a Tesla Powerwall, I think it's called, and there is an inverter, and it connects with solar cells, and it's energy storage. And there's two types of IP. Registrable rights, they require some kind of action to obtain them, and then non-registrable rights, which essentially just exist. Now, even that single device, there's likely to be, all those IP areas are likely to apply. So there's patents in a lot of the tech, so the storage technologies, connection means, and so on. Trademarks, actually, I've just come up with a list of the types of trademarks that Tesla have. So Tesla itself, Powerwall, Megapack, Megacharger, and then things like the cars, Model 3, Model X, Model S, trademarks that Tesla have that are registered. And then there's registered designs. Tesla do file registered designs, so they'll file for the shape and look of something like that. And then other technology that they develop. They've got a lot of design registrations for their car wheels, I noticed. Then there's non-registrable rights like copyright, so that can protect computer software, so the coding, and potentially even sort of user manuals that might go along with this. And then trade secrets, information that's kept as a secret, but it is useful to do so. I'm going to talk a bit more about each of these areas in the subsequent slides. Registered design. So they're there to protect the visual appearance of a product. So at least in Australia, design has to be new, so it's different from any prior published designs, and also distinctive. So in this context, it means that it can't give the same overall impression as an earlier design. You can see these kind of language keeps us in jobs. So one example of a solar cell, the design that has been registered that I found actually when preparing for this talk is one here. So a registered design is a solar cell design. It's been filed by Trina Solar Company. I don't know if that's people are familiar with that, but they're looking there to protect the the metal. I assume the metallization arrangement. And they've actually sort of honed in on different areas, perhaps where there are sort of tabbing and bus bars and so on. And they obviously see that as a distinctive, important arrangement, metallization arrangement. And they're looking to protect that through a design registration, which is, is interesting. Obviously, a lot of patents are filed in, for this kind of technology, but there's also some value in the world of registered designs. And generally, they can be used to protect the shape and configuration of a product or the pattern and ornamentation. They last between 10 and 25 years, depending on the country. Trademarks. So they're basically brands. They distinguish products and services of one entity from those of another. So they can be words, logos, shapes, colors, taglines, slogans, or any aspect of packaging, some get-up. Really anything that can act as a badge of origin and essentially a symbol of consistent quality of a product or service. So they're different from, say, company names, which are registered on business registers, but there can be a bit of overlap. So, the idea is to stop people riding on the coattails of your success. And they can also be sort of useful as shorthand in marketing messages. And there's a number of trademarks that I put on that slide. And you'll see some that are pretty familiar. UNSW is registered as a trademark, as is the emblem. I've put a few, Jinko Solar, that's a registered trademark in Australia, that logo, Hanwha. There are some others there that you might be familiar with. I don't know if anyone's willing to have a go, but if I get the digital laser pointer out, what does anyone know what that is? Crocs, yeah, so that's a Croc trademark. So they've actually looked to, it's unusual, this is where you see that there's a bit of blurring between types of IP, but they see that as a sort of a brand, that look of a Croc. That's probably pretty easy. Coca-Cola, yes. This one's, if anyone's been bit tired, Red Bull. Down the bottom, there's a tagline. Anyone giving that a go? Sorry? Go for it. L'Oreal, yes, correct. Yeah, good answer. And then this one here now. When I've shown this before, I get I get one answer, which is not the answer I'm looking for. But anyone? Tiffany is the answer that I get. But actually, this is Heinz baked beans. They've registered the colour. I think it's actually an Irish trademark, if I remember rightly. So maybe not. Maybe they didn't have success in Australia. But yeah, Heinz baked beans protecting the colour for that kind of food stuff. If you've got any questions as we go, please ask, and then of course at the end too. Copyright. Copyright exists automatically, so no registration is required. Generally covers creative works such as in art, literature, music, but also computer programs and typographical arrangements. To succeed on infringement, so to show that someone infringed your copyright, you have to prove that they've actually literally copied the work, which is different from patents and designs. Someone might infringe patent and design without actually knowing that you had a patent or design, whereas or that you were working in that particular area, whereas for copyright to come into play, someone's got to have seen what you're doing and copied it. You know, I've got there actually, you know, probably pretty familiar to everyone. There's a sort of an excerpt from a little screenshot from a journal publication with, I think, a few people from this team listed on it, and you know, of course, copyright applies to that, and it's usually sort of two worlds. There's the copyright that's retained with the authors, and then you often find those are the journal articles that are you know, can be freely accessed, so they're open to the public. And then there's copyright that gets transferred to the publisher, and those are usually the journal articles that are held behind a paywall. So the different, you know, copyright ownership that exists for those changes how people interact with the articles and access them. Trade secrets. These are things that, you know, can be kept secret, so they exist automatically again. They exist through actions taken to secure those rights, including sort of specific company policies, agreements on what's, you know, confidential, non-disclosure agreements. But the strength in trade secrets relies predominantly in the ease in which the information can be actually kept secret. So a lot of inventions, as soon as they're commercialized, the technology is out there. It's easy to sort of reverse engineer and understand what's been done. So it doesn't apply to a lot of technology. But, you know, the very clear examples are sort of food tech, where it's hard to reverse engineer, and you know, Coca-Cola is famous for having a you know, trade secret recipe, as is sort of Colonel Sanders' recipe of 11 herbs and spices. So, and the beauty of trade secrets are that if you can keep them secret, the rights, the property can be kept you know, indefinitely. There's no limit to how long it could last. So now focus on patents, which is you know, the IP right that the UNSW, certainly when it comes to our involvement, deals with the most. So what are patents? A patent is a right that is granted for something that is new, inventive and useful, and it will last for up to 20 years from filing. And it's a legally enforceable right. Gives the owner exclusive rights to commercially exploit their invention for that 20-year period. And it can stop other people making, hiring, selling, storing, importing the protected technology. And patents apply very clearly to sort of, you know, technical systems and manufacturing processes and new devices. You know, these are things that are sort of technical, that they produce, and this is a phrase from Australian patent law, an artificial state of affairs, so something that's not natural. We can also look at what's not patentable. Human beings and their process for their generation, they're not patentable. People don't like the idea that humans could be patented, fair enough. There's a bit of a grey area on that, but you know, when it comes to sort of genetically modifying, you know, humans or animals, it's not something, you know, that's easy to protect using the patent regime. Artistic creations, they you know, that's really the domain of copyright, not patents. And then, discoveries with no means of putting them into effect. Generally, the idea of discovering something alone is not enough, is not patentable. It's already existed. The fact that you discovered it doesn't make it patentable. Doesn't mean that there couldn't be something that follows that could be patented. And then abstract ideas, schemes, or plans. So you couldn't patent if you were the first to come up with addition and subtraction, you couldn't patent that. Methods of treatment and diagnosis, I haven't found this to be particularly relevant to this School of Engineering, but there can be difficulties in patenting those in certain countries. Software inventions probably more relevant. Computer programs as such are generally excluded from patentability. Now, when we sort of say as such, you can imagine that you've got some kind of scheme, business plan, some algorithms that are applied merely to a computer. That doesn't make some abstract concept patentable merely by applying it to a computer. But if the substance of the invention is something significantly more than computerization, this is sort of coming from the courts again, an abstract idea, then a computerization of an abstract idea may be patented. So, to give an example, the idea of having a new technology that displays academic qualifications on a website or something like that would typically not be patentable. On the other hand, computer software that changes the way in which a washing machine works, it provides an improved washing machine cycle, for example, that could be patented. Of course, there are a lot of things that come in between those sort of different, those levels of technicality. So there can be a big grey area in the middle for software inventions and their patentability. So the structure of a patent. Many people in the room will have looked at patents and tried to understand them. There's a title. Now, titles we usually try and keep brief. We don't want to give too much away about the technology within the title. And that's actually the same with the background. So the background of a patent usually follows the title, and it tries to set out, what's been, to a degree, what's been done before, potentially the problems with what's been done before we then describe the solution, the invention. Patent attorneys are sort of working hard at limiting, or working hard, I suppose you're not working hard, but we're more likely to limit the information than perhaps in the past that's included in the background section. And the fear we have with the background section is if we put too much detail in, we could put in so much detail that the problem, the solution to the problem becomes obvious. So it's a classic sort of trainee patent attorney thing to do, is to say, what there is a need for X, Y, Z. There's a need for the invention, and actually say almost what the invention is. And once you set that out, well, the answer's obvious. Do that. And you could imagine if you were in a dispute, someone said, well, you've set out the background, and it seems like the invention was terribly obvious on the basis of that. So, a background is useful, but it's up to the patent office to decide what's been done before. And we as inventors and patent attorneys don't have an obligation to set out in great detail what's been done before. Summary section actually mirrors what we call the claims, the patent claims, which I'll mention in a second. We have a detailed description, and that's probably the most easy to read in a way, because that's the detail we put in this patent specification that is supported by drawings and graphs and more technical information. So in that part of a patent, you tend to call a spade a spade. You actually, the reader can make some sense of it. Whereas a lot of the rest of the patent specification actually can be quite hard to read because it's a bit of legalese. And that's particularly apparent in the claims. So the claims are usually, they're a series of numbered paragraphs, typically at the end of a patent specification, and they attempt to define the protection that is sought. And when we file a patent application, we tend to look for a broad protection. So we say we claim a solar cell full stop, you know, a photovoltaic module full stop. Wouldn't that be good? Then you'd have protection. You'd have the rights to protect, and you'd get money for anyone else who produces a photovoltaic PV module. But of course, that's already been done before. The patent office, seeing that, would say, "Come on, we're not going to grant you a patent for that." That's all very well known. So what we do with claims is we try and push the boundaries a bit. We want to protect the invention as broadly as possible, so that we cover not only what you're doing, but also what people who are copying might want to do. So they might say, well, we're happy not to do exactly the same thing, but we think we can achieve the same thing in a different way. Ideally, we'd be protecting that too, that design around. So we're wanting to protect the invention as broadly as possible, but not so broad that it describes what's already been done, because then we won't get a patent. And in the patent process, we typically start off a bit broader, and then we get pushed down. The patent office saying, you know, occasionally we get, well, that's, yeah, patentable, tick. And we think, oh, maybe we should have tried harder. What we were missing, maybe we made it too easy for the patent office to grant a patent. Yeah, typically, you know, we start off reasonably broad, not crazily broad. We don't want to waste time, but pretty broad, and then the patent office will come back to us and say, it's already been done, or, you know, it's not been done, but we think it's obvious in view of what's already been done. And then we start to narrow down a little, and ultimately sort of get to a compromise, which is a definition of the invention. Usually claim 1 is the most important, that is patentable and is useful for the university, for example. And this is I threw up a claim that I found for one of, you know, the New South Innovations US, you know, patents from this team, and that's a claim to a method for processing of a crystalline silicon device. I don't know if you're trying desperately to read the small print, but you know, that's a method claim. So that's stopping someone else carry out the same method. That's the intention. But also, method claims typically protect the direct product of carrying out that method, that process. So it can extend to the actual product itself. UNSW, this team has a lot of method claim patents, and that's because you know, a lot of the ingenuity is in how you produce solar cells. Sometimes it's necessary to protect methods as opposed to the actual resulting device, because the device may generally appear the same as existing devices. So we can't, the device isn't new, but the way we got to the device is new. So that's where method claims come in. Yeah, drawings, abstract. So an abstract is, you know, just a necessary part of the specification that gets included in the patent application. So I kind of touched on this before already, just now. For a patent to be granted, the invention is defined in the claims must be new. So it's a novel, we call it, you know, it's novelty. There must be novelty. And non-obvious, so it has to have an inventive step. Novelty is fairly easy consideration. Are the features in the claim present in a prior publication or in an existing product? Non-obviousness is where, again, you know, we get more involved, and it's there's all sorts of arguments for and against obviousness that we have to consider. And this is all assessed in light of the prior art, so, you know, what has been done before the application was filed. So we've got some examples of prior art, you know, earlier patent documents. More often than not, that's the prior art that we have to deal with. It's amazing how much is disclosed in earlier patent documents. We're so often presented with an invention, people say, no one's done this before, I've checked. And usually the case is that no one's commercialized it before. But there's often all sorts of disclosures in the, you know, in patent databases where people have come up with similar ideas. They may never have got it to market, and that's probably the case for most inventions that are patented, unfortunately. But it's a public disclosure. It's out there. Someone's already, you know, described all or part of the invention. Journals, books, other publications. They're you know, publicly available information on the internet. It's all sort of connected together. Disclosures during public meetings and conferences. This is a good one. You know, people go to conferences, they want to talk, they're there to talk, and that's where a lot of disclosures can come out. Now, a chance sort of chat, at the bar at the end of a conference, whether the patent office or anyone ever really becomes aware of that, public disclosure, quite unlikely, but certainly when there are, abstracts being published, conference abstracts and so on, they do come up. So, all in all, what's the sort of take home at this little point? At this point is keep things secret. So, you shouldn't talk about new developments to any third parties, to someone where there's not some kind of existing confidentiality arrangement until you've considered your IP position. Now, perhaps that's not realistic for absolutely everything, but hopefully as we go, continue this talk, it can help people get that sort of IP mindset that can sit with their research, for example, and they can think, oh, that's a pretty neat thing, that's something that someone would possibly want to do, or we could commercialize. I'm going to be a bit cautious about who I tell, and that's probably all right to talk about the person next to you if they're, your colleague, part of your team. But emailing your mate at another university or talking about it at a conference, but they're highly risky, and where there's doubt, go over to the knowledge exchange team and talk to them about whether it's something that should be protected. In fact, maybe we'll probably, we can talk more at the end about any sort of relevant processes for that. Patent process. I'll just, have I got my, yeah, I do. So we could talk for a couple of hours about the patent process, and whether you would all be awake at the end of it, I'm not sure. But this is a very sort of basic timeline of the process. Hopefully it's not too small to see, but we typically start with filing what we call a provisional application. Provisional application is a patent application that can't become a granted patent, it can't become a full granted patent, but it does establish a first date, and it's, it gives patent pending in effect. When you see something that says patent pending, that's because they filed a patent application, and a provisional application will do that. We normally file in, for Australian universities and companies, we normally file first in Australia. And just filing in one country like Australia effectively gives you patent protection, pending patent protection around the world. You have to take steps in future to secure that protection ultimately around the world, but that first filing is good enough at that stage. So provisional application lasts for 12 months before it lapses. And before typically right at the end of the 12 months we do it, but before that 12-month period expires, we have to file a complete application, usually something we file as a PCT application. That's also known as an international patent application. That's a type of complete application, and that can lead to ultimately a granted patent. PCT applications, however, there's no such thing as an international patent, full stop. They have to ultimately be divided out and entered into countries of choosing. So in a way, PCT applications, what they do is really buy about 18 months of delay before filings have to be made in all the countries where you want protection. They're useful in other ways too, because there's, the patent's published at that, the patent application is published for the first time typically 6 months after filing, so 18 months from the first ever filing date. There's a sort of an examination process that goes on, which gives an indication of the chances of success of the patent application, even though it's non-binding. So it's just the international authority giving their opinion on whether it could be patented. But ultimately, that PCT application has then to be entered into, say, the US, Europe, Australia, Japan, China, and it's when it enters into those countries that the real examination takes place, because those countries are deciding whether to grant you a monopoly right in their country to stop others competing in your technology area and what's protected. So that's where it gets more serious, and it gets more expensive because the whole process is sort of magnified. In fact, it multiplies. You file in multiple countries, there's multiple sets of fees. So you could have filed on day one in US, Europe, China, but it's expensive. So the whole process up to sort of the last two parts of that timeline, so that, you know, up until this point is really, the best thing about it is you have sort of pending protection at lower cost. Because more often than not, and particularly universities, they're not desperate to get granted protection immediately. They just want to secure some provisional rights, and you know, limit costs perhaps until there's a potential investor or there's an opportunity to assign or license. So this is all very useful, this sort of delaying process where you get more information about about the patentability. Until then, you have multiple applications in countries of your choice. They go through examination, can be backwards and forwards with the patent office in those countries, and hopefully you get a granted patent at the end, and that can be enforced. It could also just sit on you know, certificate can sit on the wall behind a desk and look impressive. That's not really why we do it, but for some patents, that's the only value they might have, which is you know, an important thing to consider, and that is at every step of the way, what is the patent application? What is the ultimate patent? What is it doing for you? Is it worth it? Is it a technology that you're still interested in? Is a technology that competitors would be interested in, that the university is interested in commercializing? And every sort of step in this process, and there's multiple steps within this, consider, you know, is it worth going ahead? What's the value in going ahead? Okay. Does anyone have any questions about that timeline of the patent process? I'll keep going. As I say, feel free to ask questions at the end or even after the talk's formally finished. Patent rights and limitations. So there's a question there, true or false? If you have a patent that covers your product, you are free to exploit your product. Does anyone want to guess the answer to that question, or does anyone know it? Yeah. Everyone's happy to let me give the answer. Well, it's false. So I'll go into that in 2 slides' time. True or false? If someone has a patent that your product would infringe, you can't get your own patent for your product. Again, that's false. So why? Well, there's an example here. Apple, I'll read it out. You know, Apple has invented I made this up. This isn't true. Well, some of it, I guess, is true. But Apple has invented the Touch ID fingerprint scanner and patented its invention. A startup has invented the Touch ID health monitor, which allows a person's health to be analysed whenever they use a fingerprint scanner. So in this instance, the startup may be able to get a patent for their invention. So it's clever, it's new, and potentially it's inventive. So they've come up with something that meets their criteria for patentability. But they can't exploit the technology, and that's because Apple, well certainly without Apple's permission, because Apple has the sort of the fundamental protection for the scanning technology. They've patented that. You know, the next slide probably covers it. You know, patent gives the right to exclude others from, you know, exploiting the invention, but it doesn't give you a right to exploit the invention. You know, you can get a patent, and it's a very simple. You know, thinking of other examples. You know, with you know, I've got a water bottle here. You know. People patent bottles, and it might be the sort of the way that you know, it seals. There's all sorts of, you know, ridges and angles, and it probably provides an efficient way of sealing the bottle. So, you know, you could probably patent that. But you say, actually, do you know what we want to use? We might want to use a certain type of plastic because it's easy to manufacture or whatever. Well, someone might have patented that plastic, you know, so you wouldn't be able to exploit this bottle because of that. Often there's a lot more overlap, subtleties, but you know, that's the kind of sort of situation you could be in. But patent, you know, just because you patent something doesn't mean others can't get a patent. Again, in that example, someone may have patented the plastic 15 years ago, doesn't mean you can't get a patent for the new type of sort of sealing arrangement of the bottle. So this now links in quite well with the idea of, concept of patent searching. Now, I think, a lot of researchers, particularly if they're at a point where they're looking to patent, their technology, they'll likely be asked, well, what's been done before? Have you done a patent search? And the type of searching they're typically doing there is a novelty search, a patentability search. And the key is to identify what's new about the invention. Has it been done before? What parts of your work are new? It helps understand the likelihood of patent, of success. Whether it's worth proceeding with the patent application, the success of the application. In theory, it could be used in a way to attack others' patents too. Another type of search that people do is an infringement search, freedom to operate search, FTO, or a clearance search. There's sort of much of a muchness. And what you're doing there is trying to identify whether there's an infringement risk if you exploit your technology. Universities tend to have to worry about that a little less. They tend to partner with other organisations, and those are they're the company. The companies are the ones that have to worry about it a bit more. But it's, I think there's still some relevance in that those companies want to, know at an early stage whether there's an obvious infringement or risk. And if there's a general awareness about, what competitors are in the area, whether they're, filing a lot of patents in this, for this technology, that can be important and useful for the whole commercialization process. Now, that kind of searching, it doesn't, with my bottle example again, you're from the novelty search might have focused on the sealing arrangement because that's sort of the exciting bit. But your freedom to operate search might have looked to see whether anyone's got patents for that sealing arrangement, but also whether there's patents for the plastic or for the manufacturing arrangement or for the way in which the motif is applied to the outside of the bottle. Anything that could potentially be a risk. There's a table there. I mean, maybe it's more useful if the slides are shared to have a look at it, but it really is there to sort of highlight differences between those two types of searching, novelty searching and infringement searching, because so often people really confuse the two. Novelty searching, anything that's public is relevant, it doesn't have to be a patent. Infringement searching, well, you're looking to see if you infringe patents, so there's no point in searching for journal articles. So there's two very different considerations. I'm doing very well for time, just say. So if there are any questions, please ask. But as I say, we can talk at the end. But inventorship and ownership is a very important consideration in the patent process. Why do we care about it? Well, inventors are the first owners of an invention. So if you've invented something, at least for a very moment in time, you're the owner of that invention. But more often than not, there are agreements that are established, that are in place to transfer ownership from an inventor to another party. So, for example, the university. So who is an inventor? It's not always straightforward to determine, because often there's a lot of people who work on a project, but doesn't always mean they're an inventor. In Australia, case laws told us to look at whose contribution has had a material effect. In other words, one way of looking at that is, but for their involvement, would the invention have come about? But even that's confusing. Well, someone had to turn the light on in the laboratory, although we've never been able to have done it. It doesn't make them an inventor. So you can see how there's still sort of, a grey area again. Did they contribute to something important technically? Did they have did they bring about some material effect on technical material effect? did they contribute to something that's particularly useful in that respect? And we often have to do sort of, inventor audits, particularly where sort of, inventorship isn't particularly clear. And that can often be particularly important where there's multiple parties involved, because it's higher risk in a way. So if everything's happened within a university, you can probably say, well, look, they may be invented, they may not. Let's list them. They're part of the university anyway. The rights owned by the university. We want to get it right. Don't get me wrong. We don't just list people for the sake of it. But if it's a 50-50, it makes sense to list them and ensure that there's a proper chain of title to the university. If there's multiple parties involved, there's people, collaborators, the question of whether someone is an inventor or not could actually result in a part ownership of the technology potentially, which has big implications. So something like that, you might have to take even more steps to be sure that you've got inventorship right. As I say, you want to get it right in all instances, but there are sort of levels of how much effort you put into absolutely nailing it. But typically we are on the side of naming inventors rather than leaving them out, because once you've named them, it's easier to establish a chain of title to the owner of the rights. There was a sort of court case in the US, and I'll probably muddy all this a bit, but it was Ethicon v. US Surgical, and let's say, I think this is right, Ethicon sued US Surgical for infringement of a trocar, surgical trocar, a sort of leady type invention. Ethicon had an exclusive license to exploit this patent, so they had the right to sue other companies as a result. And the technology was invented by sort of inventor A, and he collaborated briefly with another person. I think maybe over an 18-month period, no real engagement no formal engagement, but the other person helped out. Sometime later, inventor A filed a patent application. It got granted, exclusively licensed it for millions of dollars to Ethicon. Ethicon then went, well, we've got these patent rights, let's use them. And they sued US Surgical. And US Surgical sort of, well, I imagine going, oh dear, we're in trouble here. But they did their due diligence. As part of the court process, it became recognized that this other inventor B had been involved. And inventor B actually, so we talked about the claims, inventor B had only contributed to a couple of, say, 55 claims. And those claims weren't relevant to US Surgical. They weren't doing that part of the technology, for what it's worth. But the important point was that the inventor B should have been listed, because they contributed to two of 55 features that were considered sort of inventive in a way. Should have been named. So effectively through that process they forced inventor B to be named. Inventor B acquired in effect part ownership of the patent. US Surgical then got a license from the inventor, the sort of inventor B, or I think it was a license or some kind of transfer of rights. And then the court case goes away because they're, like Ethicon, they're joint IP right holders for this. Had the early days, inventor B and inventor A, particularly inventor A, sorted out with inventor B, named that inventor, ensured the rights were in place, then exclusively licensed it to Ethicon, all would probably be well. But it's a great example of how important it can be to get this right. So non-inventor if merely following instructions, performing routine work, constructing a product to another person, design only a figurehead. So, if it's someone just turning the dial, say, can you just, turn the dial, record the numbers over the next hour, they're not doing anything inventive, even though they're contributing to the sort of the development of the product. Only a figurehead. There's a temptation to name university professors on patent applications because that's what we always do. But it's not a journal article. Journal articles, yes, maybe, but did they, were they actually involved in the invention from an inventive perspective? Maybe they were there for the grant or the funding or something like that, but were they? Did they contribute to the invention itself? So once, inventorship's worked out, then what happens with ownership? Inventors are the first owners. Well, the ownership can transfer through a contract of employment, consultancy agreement, some kind of additional IP-specific agreement. And the university takes steps to ensure that, if appropriate, or I say if appropriate, there can be technology that's developed outside the university for something that someone's not, involved with at all in their day-to-day job. That I don't think the university would be expecting rights to transfer as a result of that. But if appropriate, they want to ensure that they own the technology and inventions developed by employees, consultants, and potentially third parties. And that's important because, the university would be investing a lot of money and resources in that, and a key part of doing that is, I perhaps should let the knowledge exchange team talk to this, but a key part of that is knowing that they've got the ownership of the technology that they can then work with potential investors, other companies to exploit. So why does UNSW protect IP and what is the approach? Another question which I'll probably end up answering is, true or false, a patent is worthwhile only if you can afford to take big companies to court. Now everyone sort of throws that as patent attorneys, say what's the point of never be able to go to court? I mean, there's a little element of truth in that, very small, but if it really, look, it's false. There's a lot of value outside of that domain. So IP is a property that can prevent, deter infringement or theft by others, so that's an important part of it. But it's a property, so it's a property that can be sold and licensed to partners. It's something that you can own and you can get money for. It typically is fundamental to starting for a technology startup. It often forms the basis of that startup, and critical in ensuring that there's, securing investment, getting funding. Most certainly, if big companies are involved, they want a return on their investment, and one way they can see that can happen is by ensuring that there's IP rights, that they can have a monopoly on what they're, investing in. So these are, 3 slides. Helpfully provided by Barong, and to discuss, to illustrate the UNSW approach to IP management and commercialization. This is fairly basic. First slide, there's a disclosure of the technology, and I believe that's to the knowledge exchange team rather than to the world. A review, so obviously sit down, discuss, consider whether it's something that should be protected. Then proceeding with the protection, typically a patent application, and then commercializing it. And commercializing it can come at any stage to a degree. Usually you've got to file a patent application first before you can then talk to partners, but not necessarily have a granted patent before you do so. Pathways for commercialization. Look, there's a number of sort of pathways, and they can result in licensing or establishing of spin-outs and and start-up companies. There's a distinction there between technology that's owned by the university and technology that might not be, but this can still be support in both instances from UNSW. And this is, I'm almost getting to the end here. This is a busy slide, and I'm not going to talk to it, but it's there in the slide deck. So there's obviously a lot of thought and consideration gone into establishing a staff spin-out, but there are clearly processes that the university have to do so. Please have a look at this slide and talk to the team, the knowledge exchange team after this talk, or obviously at any stage that's suitable. So, summarising, be aware of the different types of IP available. Patents are probably most relevant, but there are other types of IP registered designs. You saw that was useful for a company to protect their solar cell arrangement. Be aware of what IP exists, the value that protecting it can bring to a project. We talked about the value in commercialization, getting funding. every step and turn, ideally, consider if you've come up with something that could be protected, should be protected, and discuss that with the knowledge exchange team. I think I should have had lunch. I'm not sure if the microphone's picking up my stomach. Don't publicise technical details of your work before the IP position is considered. So don't disclose the invention to the world before you at least consider the opportunity of protecting it. And then we talked about sort of being aware of novelty and freedom to operate issues. So the differences there between sort of patentability issues and whether there's clearance freedom to actually exploit the technology. And understand the importance of identifying correct inventorship and really the knock-on effect that has to ownership. So I think we're sort of 5 minutes to 2. I've got any questions slide. Please do ask questions now or find me after the talk, and even feel free to email me. So. Go ahead.
Thanks, Eddie. Just on the example that you've showed that you might be able to get a granted patent, but doesn't mean you have the right to exploit it. Do you mind elaborate on that example of why that's the case? Yeah.
So it goes back to my bottle example. So it's very useful to obtain a patent. It means someone can't copy what you've protected. But it doesn't mean that you're not copying something else. So whether that's, I suppose my Touch ID scanner, someone had protected the fundamental, the basis for the technology. They were the first, Apple in this example, had protected the fingerprint scanner. So they've got a granted patent to that. As a result, anyone who exploits the fingerprint scanner is going to infringe the Apple patent unless they have some kind of agreement. Maybe they bought the technology off them or something like that. But that doesn't mean that other people can't innovate on top. They've come up with this health, health monitoring feature. They can patent that. That's new, inventive, but they can get a patent to it. But it doesn't mean that they've got the right to go ahead. They still have to worry about the protection that the first inventor of the technology that they stood on the shoulders of has rights that could be problematic. I think maybe it's not the best example because Apple will they deliver their iPhone and people can use it. They can have third-party apps and so on, and there's expectation that they'll only apply to people who are using it will have bought the iPhone legitimately in the technology of the iPhone. So. More often than not, third-party apps, they're okay. They're connected suitably with Apple. But in many instances, that's not the case, and that the innovator is reliant on pre-existing patented technology.
Thanks, Eddie. I have a question about the journal article and the patent difference. When we want to apply for a patent, we have to do the novelty search. We have to search for the journal articles published.
Yeah.
But for us, when we publish some journal article, we don't have any protection for our innovation.
That's the most common sort of situation that researchers are sort of involved in, where IP comes an issue. Ideally, before you have a journal article published, you have considered whether this is something that could be protected, and then talk to the research team, the knowledge exchange team, to see if that's something that potentially should be, publication should be avoided or delayed. If it's potentially very important to protect it, it could be commercially important. I guess the key take-home message from this talk is to have that in the back of the mind before publication. Now, there's often a bit of a period between submission of an article and review and before it's published, and maybe not always, but I often see that that's a confidential review, so that's not a public disclosure, but I wouldn't say that 100% that's always the case. But it's not uncommon for us to be filing patent applications within that window where someone goes, oh my God, this journal article is about to be published, we need to file a patent application. We've got 3 weeks, 2 weeks, a day. Don't leave it a day, the patent's not going to be very good. So in terms of how you find those search, obviously you know about your own article, but in terms of finding prior art, which could include earlier patents and journal articles, I imagine people in this room are better at finding journal articles than I am, but there are obviously lots of search, databases out there. Patent databases too. So there's Google Patents is a really easy search database to use, and it has pretty much all patents. And then there are commercial search databases we use that are easier to, or more sophisticated, but still essentially contain the same information. So Google Patents and Patent Lens, there's a number of publicly available search databases that can be used. Great. Well, it's 1 minute past 2, so I think we're pretty much on time almost. And I guess I'll finish there. Barong, do you want to?
Yeah, thank you so much, Eddie. So, yeah, very nice talk. Both to the refreshment of the IP or the first time to know what is the IP. And today also we have our knowledge exchange team, the commercialization lead Trina, and the intellectual property manager Desmond. So if you have any questions regarding the IP, just come to us, and we are a great team to help you with the IP protection. And thanks Robert and Kevin to organize the seminar for us. And we are looking for maybe the next talk for more detailed IP knowledge education for us.
Please,
and thanks again.
Yeah, excellent. Well, pleasure. Thank you, everyone. Thank you.